Hey, this is Kent Jones with Jones and Associates, attorneys at law. We're located at 1441 Guthrie Drive, Cleveland, Tennessee. We're in Suite 101, zip code 37311. It's a beautiful, remodeled building, heritage office building, big white building, right behind the Burger King on 25th Street in Cleveland. We've been going through a book that I wrote in 2015 on what you do when you suffer a personal injury in the state of Tennessee. And what I wanted to go through briefly today is types of claims. There are a lot of different types of personal injury claims, and by no means do we intend to cover all of those in this particular book. Negligence claims may include car accidents, slip and fall, malpractice, toxic torts, and many others. In 1992, Tennessee came out with the seminal case, McIntyre v. Valentine, doctrine of contributory negligence. Abolished Tennessee's using a legal doctrine called modified comparative negligence or fault, which means that a negligent plaintiff, i.e. you, if you're injured, can recover if your negligence is less than the defendant's. Each defendant is now liable only for the portion of the plaintiff's damages occasioned by that defendant's negligence. Under a strict liability theory, a person or company who has, maybe put a dangerous product on the market is going to be liable. Products liability cases are extremely interesting, and they're very tough to handle. We've driven some up through the Sixth Circuit Court of Appeals, and essentially they're going to sound in statute, negligence, number of different, strict liability maybe, a number of different things. And when you start dealing with products liability, it's detail oriented. It starts from gathering the correct information from the beginning. Do the most that you can to help out your lawyer. Pictures, statements that you can put together. I've had some clients come in with affidavits of doctors that they've been seeing. I've drafted affidavits for the doctors to originally get them on record as to that person's status at that point in time. Tennessee still doesn't. Let me back up. In federal court, where you may end up in products liability, because you're probably going to be suing people all over the place outside of Tennessee. And the first thing that'll happen if you file a state lawsuit is they'll come in, the defendants, and remove it to federal court. Well, you got much stricter standards there. The most recent seminal U.S. Supreme Court cases on drafting a complaint are Ashcroft versus Iqbal and Atlantic Corp, Bell Atlantic Corp versus Twombly, and in both of those cases have been talked about in detail by the courts of appeals all over the United States of America. And what they mean is you can't just do what we used to call form pleading. Well, what's form pleading? Form pleading's, had an accident. They were negligent. They hit me. I'm hurt, and that's it. You gotta be more specific. And in the cases that we've been involved in, what they're really looking for is, is there some precedent out there where it's happened before? And there are some consumer product indexes that you can look at to find out if anything's been reported on a product causing what you have. And if you can find that, it's wonderful. It helps you get through the gateway. If it's a case of first impression, it's going to be very very hard. But I'm not dissuading anyone from going after it. Just make sure you talk to your attorney closely. Tennessee Supreme Court has not adhered to those strict standards. There are some cases in Tennessee that you have to plead with particularity, maybe a TBC Act or something like that, but you're a little looser, and you can do a little more form pleading, but it is important to be as particular as you can. In 2008, there were reforms to the medical malpractice and nursing home abuse statutes, and that reduced lawsuits considerably. With respect to physicians, there's a more stringent certifying process before a lawsuit can be filed. You're going to need an affidavit from someone who knows what they're talking about, kind of close to you. Also, plaintiffs are going to have to notify the defendant 60 days before they file a lawsuit. You can't just file one and surprise them in those cases. Under a wrongful death theory, whoever is liable for the accident that caused the death is, if negligent, may be liable to the decedent's estate for such things as economic loss, damages such as loss of companionship and affection. I'm going to briefly, in next segment, get into workers' compensation law. It's far too complicated now to cover in a chapter, but we'll go through the basics of it. So anyway, thank you. Hope you're having a great day. We'll talk to you. Bye.